So finally, the last thing I'll talk about in terms of opportunities for increasing rent is something that it sounds a bit arcane, and it is something that exists. I see it come up more often in circumstances where you have rent controlled apartments that didn't get increases for a lot of years, but it is also in the rent stabilization law and is something that can be applied for. The presence, what they say in the rent stabilization laws, the presence of unique or peculiar circumstances materially affecting the initial rent, and that results in a rent that is substantially different from the rents generally prevailing in the same area for substantially similar housing accommodations, can be a grounds to ask DHCR to increase the rent. And over the years where I have seen this come up more, I just tried to give you a couple of case examples here. Sometimes, I've seen this scenario more than once. You have a building, someone lived in there who was the prior owner's family member or friend. They got a sweetheart deal on a lease for a long time. They may not even have paid rent, or they paid a very low rent and no one ever increased their rent. No one ever bothered to file MBR increase applications every year for a rent controlled apartment, not because they were violations, just because they just were friendly with someone or it was too much trouble for them to do it. So new owner comes along and you've got an apartment, you have a fair sized apartment and the rent is like $250 a month, and it just seems out of whack with everything going on in the vicinity for that size apartment. You can apply to DHCR, you can make your argument as to why you should get an increase for unique and peculiar circumstances. And sometimes that works. And sometimes you get a rent increase because of that. And, there's one case I cite on the second page here, that this 207 Realty, they just say the purpose of it is to bring rents that are artificially depressed in line with similarly situated housing accommodations. And one thing DHCR has information on that they can look at, or you can ask to look at yourself if you have one of these applications, is there is information of rents by zip code, like the average rent for, say, a 2-bedroom apartment that is kept by DHCR for use when they have to set rents under the default method in overcharge situations. So that information is available. You can ask DHCR for information, what's the rent, the prevailing rent for a 2-bedroom apartment in zip code 10013, for example. And that may be one of the things they look at in considering what to do. I had a case that I was involved with recently that I mentioned here just because, again, it was a case where, at least for today, we have a favorable ruling from DHCR. It is under appeal, but I think there's language in here that the DHCR would uphold. It was a case where someone was converting a building back in the 80s and had some tenants in the building that they were trying to negotiate with, and basically gave a tenant a $300 a month rent for a large unit in forever. There was no rent increase provision. And then at some point, through some other litigation, it became clear that the apartment was subject to rent stabilization, and the rent was still sitting there at $300 a month. And a new owner bought the apartment and applied to DHCR and did get the rent increased. It's still, under $1,000 a month, but it was, given that the base rent was $300, was fairly significant. And one of the things that the DHCR, the rent administrator, noted was that, you've got a lease, it's rent stabilized, the prior owner's not even there anymore, and having a rent stabilized unit where you have to waive your right to a rent increase forever is unenforceable as a matter of public policy. Now, that is consistent with a lot of DHCR decisions and court decisions that have gone the other way, that, tenants can't waive their rights under rent stabilization. And sometimes if they have, through court stipulations, there can be future litigation where that gets upended by another court saying, that was against public policy, whatever you did. So this at least consistently applies the law and gives owners some opportunity to get rent increase in unusual circumstances. So there have been many, many motions made in housing court certainly within the past 3 to 6 months, where owners are asking courts to vacate the ERAP stays. And the results are mixed. Sometimes you'll have judges who will say, statute clearly says there's a stay of the proceeding while the ERAP application is pending. Sometimes it's clear that the ERAP application isn't going to go anywhere. For example, someone who was the building super, who is now the owner is seeking eviction because the employment was terminated and they're not being accepted as a tenant, that person will file an ERAP application, but that person hadn't paid rent. So there's not going to be any reason for them to get ERAP because they didn't pay rent while they were living in there as an employee anyway. So owners in a case like that may be able to get the ERAP stay vacated because it's not going to go anywhere, and it would be an exercise in futility to go with that. So there's a lot of the decisions are interesting, and they may be informative for people. And I will say, just to give Habitat and LVT a little plug, I mean, that LVT is one place where a lot of those decisions have been summarized and are certainly of interest.
You mentioned that tenants can challenge IAI rent increases. And let's say tenants are in residence and they're not a new tenant. They've been there, they've had the improvement. Are you seeing any cases like that as the editor of LVT? Do you see cases like that where tenants are challenging those rent increases, or are they mostly from new tenants coming in challenging improvements that were done before they became tenants?
There is a mix. There are some cases, and sometimes it depends on the facts. There are cases where a tenant will file an overcharge complaint or raise overcharge as a defense in housing court and say, and sometimes it comes up if they're deregulated, and sometimes they're not deregulated. They'll say, I've been overcharged, and part of the reason I've been overcharged is that the landlord collected IAI increases, and sometimes it's more than the 4 or 6 years ago. And this was the result of fraud, a fraudulent, attempt to deregulate the rent. And therefore, the DHER or the court should break down the wall, the 6-year statute of limitations, and look at the rent. Now, DHER or the courts, you can challenge whether an apartment was properly deregulated more than 6 years ago, and DHCR will ask owners to produce documentation showing how an apartment got deregulated, but it doesn't always go anywhere. Sometimes they will just say, look, it's too old to, especially if it's simply an overcharge claim, it's too old to look at what happened 15 years ago. And if you want us to look at what happened because there's rent fraud, a rent increase by itself isn't enough. The rent went from $750 to $1,500, and whether you have IAIs that support that is one question. But whether or not you can say that in and of itself is fraud, DHCR is more likely to say that it's not. So it's not impossible to do, but it's more difficult to simply challenge IAIs, because they were old, especially if it didn't result in deregulation.